Hi, everyone, and welcome to the inaugural episode of the Bridging the Gap Between Theory and Practice webinar series, proudly presented by World Heritage USA, the supporting organization of ICOMOS USA. This series is designed to provide specialized preservation training to emerging professionals, effectively bridging the gap between academic theory and real-world practice. However, many of our discussions will also be relevant to established professionals looking to delve deeper into topics they may not be exposed to on a regular basis. No matter at what point you find yourself in your preservation career, I think we can all relate to learning about a topic in a classroom or a book, thinking that it's pretty straightforward, only to then be faced with more nuanced challenges the moment we're asked to put that knowledge into practice. Most of the time, the theory we learn doesn't prepare ourselves for the challenges of applying knowledge in real-world scenarios that present diverse economic, environmental, or political challenges. And how can we, as students and professionals, prepare ourselves when so many of these challenges differ from state to state, or even between cities and neighborhoods? So in planning this series, we surveyed both emerging professionals and established professionals to identify what topics or subject areas they wish they knew more about when making the transition from university studies to professional practice. What additional knowledge or resources would make that transition easier? And what would make new preservationists that much more successful in their careers? Based on your answers, we've created this 6-part webinar series titled Bridging the Gap Between Theory and Practice with the generous support of the Historic Preservation Education Foundation. Today's inaugural episode will focus on heritage legislation in the United States. Legal frameworks play a crucial role in how we identify, protect, and manage historic and cultural resources, and understanding the backgrounds of these policies and the roles they play in preservation practice is essential for professionals working to safeguard heritage sites throughout the country, whether through advocacy, planning, conservation, or community engagement. The United States boasts a robust system of heritage laws and policies that operate at federal, state, and tribal levels, each playing a pivotal role in the protection and management of our diverse heritage assets. To help us navigate this important topic, today we'll be joined by 2 distinguished experts who will share their knowledge and insights on today's evolving landscape of heritage legislation, both at the federal and tribal levels. Chris Cody, who is Associate General Counsel for the National Trust for Historic Preservation, and Shannon O'Loughlin, who is the Chief Executive and Attorney of the Association on American Indian Affairs and citizen of the Choctaw Nation in Oklahoma. We encourage you to engage with today's discussion, ask questions via the Q&A feature at the bottom of your screen, and take advantage of this opportunity to gain a deeper understanding of how legislation shapes heritage preservation efforts across the country. On the Bridging the Gap webpage on our website, you'll soon be able to access additional resources for further study and reference provided by Chris and Shannon. And we hope this episode will introduce you to a new topic or clarify some questions you had about heritage policy, and that you'll be able to use the additional resources to make improvements to real-world applications in your state, community, or career. So thank you all for being here, and let's get started. Our first speaker, Chris Cody, as I said, is Associate General Counsel for the National Trust for Historic Preservation. He specializes in legal advocacy, including federal administrative processes like Section 106 and NEPA, local and state historic preservation laws, and litigation. Chris previously served as the Deputy State Historic Preservation Officer for the state of Arizona and as Manager of Advocacy and Staff Attorney for Historic Charleston Foundation in Charleston, South Carolina. He holds a BA in History from the University of Wisconsin-Madison, a JD from the University of South Carolina, and an MA in Preservation Studies from Tulane University. Chris, thank you so much for joining us today. I'll turn it over to you.
Thank you so much for that fantastic introduction. As Katelynn said, my name is Chris Cody, and in the first part of this webinar, we're going to briefly review the basic framework for historic preservation law in the United States. Now, each legal topic that I'm going to discuss is very complex, and I'm going to share a lot of laws and legal concepts with you. We're going to start with federal law and then work our way down to state and then local laws and end with universal constitutional law. My goal is to show you the many, many ways in which historic preservation interfaces with the law and to hopefully leave you with a high-level understanding of the legal framework that undergirds historic preservation in this country. First, let's begin with some quick background on historic preservation law in America. Now, historic preservation first began to emerge as a field of study in the 19th century, and in America, the first historic preservation organization was the Mount Vernon Ladies Association, founded in 1853 to save George Washington's home, which they successfully did and still own to this day. In 1906, the first federal law concerning historic preservation was passed, the Antiquities Act, which empowers the president to create national monuments, amongst other things. This is an extremely relevant law today, as numerous 21st century national monument designations are currently under threat of revocation. In the 1930s, the first local historic preservation ordinances were enacted, first in Charleston, South Carolina, and then in New Orleans, Louisiana, as well as another federal law concerning historic preservation, the Historic Sites Act. Then, in 1949, Congress chartered the National Trust for Historic Preservation, where I work. In the 1950s and 60s, a new phenomenon emerged in America's major cities. Urban renewal, as it was called, led to the rapid destruction of America's historic urban cores as cities were reoriented to serve the automobile. The pace and scale of this destruction helped fuel the rise of the modern historic preservation movement. No single event contributed more to the rise of historic preservation in America than the destruction of Penn Station in New York City in 1963. An architectural masterpiece designed by McKim, Mead, and White, the horrific demolition of Penn Station became a major rallying point for historic preservation and attracted many high-profile advocates to the cause. Shortly thereafter, in 1966, Congress passed the National Historic Preservation Act, which is our nation's most important historic preservation law. The NHPA, as it's known, fundamentally changed the federal government's approach to historic preservation, and notably created historic designations for state and locally significant historic resources, whereas previous efforts had only acknowledged nationally significant historic resources. The NHPA created a number of crucial entities, programs, and legal requirements that today form the basis of the federal government's historic preservation policy. Those include the National Register Program, the President's Advisory Council on Historic Preservation, state historic preservation offices, and the Secretary of the Interior standards. The NHPA also created the Section 106 process, which requires consultation with SHPOs for federal undertakings, and Section 110. There are a number of historic designations that exist in federal law, and I think it's important to clarify their hierarchy and meaning. At the top, the most historically significant places in our country are designated as national parks or national historic sites, or as national monuments. And those properties are directly operated by the National Park Service. Just below them in significance are National Historic Landmarks, or NHLs, and below NHLs are National Register properties. For both NHLs and National Register properties, there are both individually listed properties and districts. They're both individually listed properties and districts. And within districts, properties can either be contributors to the district or non-contributors. And while there are many other designations out there, the National Register and NHLs are the designations that are most prevalent and most relevant for our purposes here today. To dive just a little bit deeper into the National Register, to be listed on the National Register, the law requires that a historic resource meet one or more of these four criteria, and that it retains sufficient integrity, which today is a relatively controversial requirement. The four criteria are A, that it's associated with a significant event in history, B, that it's associated with a significant person in history, and then criteria C generally deals with outstanding architectural resources, and D typically concerns archaeological resources. One of the most significant provisions of the NHPA is undoubtedly Section 106. It's triggered when there's a federal undertaking, which doesn't have to be direct federal action. It can be a permit issuance or providing funding. And when that undertaking has the potential to adversely affect historic properties, that's when Section 106 is triggered. When that happens, the federal agency is required to stop, look, and listen, and consult with the local SHPO and take measures to avoid, minimize, or mitigate any potential adverse effects of the undertaking to historic properties. It's important to note that Section 106 is a process, not an adjudication. This is a map of the process. So Section 106 will actually be covered in a future webinar. So I won't go into more detail about all the steps of this process, but it says a lot that this particular set of laws is so important that it has its own upcoming webinar. Moving on to another set of laws in the NHPA, Section 110 creates internal requirements for federal agencies. It charges agencies with establishing preservation programs and also with pursuing historic preservation as a policy goal. It's important to understand that there are no public Section 110 reviews like there are for Section 106. This is an internal agency law, but federal agencies have been found by courts to be in dereliction of their Section 110 responsibilities, so it's still a meaningful law. Section 110 has two other noteworthy provisions I'll briefly mention. Section 110F provides heightened protections for national historic landmarks like Evergreen Plantation shown on this slide. The statutory language, to the maximum extent possible, is very strong. Section 110K deals with anticipatory demolition. For example, situations where agencies demolish resources before completing Section 106 reviews, despite knowing that those reviews are required. This does happen. The images on this slide are from a case that the National Trust litigated where that was exactly what happened. And as you can see, Section 110K bars offenders from receiving any permits or assistance from the federal government if anticipatory demolition has occurred. So again, a very powerful law. Another important federal historic preservation law is Section 4F of the Department of Transportation Act. This law concerns only transportation projects like highway or rail projects, and it creates a very high preservation standard for those projects. Under Section 4F, a transportation project that adversely affects historic properties cannot proceed unless there is, quote, no feasible and prudent alternative, and all possible planning has occurred to minimize harm. This is a much higher standard than Section 106, which, as we discussed, is merely a consultation process. Another important federal law to be aware of is the National Environmental Policy Act, or NEPA. NEPA is a very broad law that considers a wide range of factors and multiple other laws, including Section 106, and historic and cultural resources are specifically considered under NEPA. Like the Antiquities Act and national monuments, this is an extremely relevant law today as NEPA is poised to undergo significant changes under the Trump administration. So that's federal law. Let's move on down now to state laws. First and foremost, let me preface this by making it clear that every state is different. No two states do this exactly alike, but in general, this is how historic preservation laws are set up at the state level. Most states have a State Historic Preservation Act, which are echoes or even straight up copies of the NHPA. Just like the NHPA, they typically require that state agencies consult with SHPO for state undertakings, in the exact same way that 106 requires that consultation for federal agencies for federal undertakings. For example, the image on this slide is of Tombstone Courthouse State Park in Tombstone, Arizona, which is an NHL and owned by the state. So the preservation of this building is entirely a state enterprise and thus falls under Arizona's State Historic Preservation Act rather than federal law. State environmental protection acts also exist in nearly every state and are typically echoes of NEPA at the state level. Some of these laws consider historic preservation issues more than others, and in some cases, state historic preservation acts are even part of state environmental protection acts rather than independent laws. Again, every state is different, but these are very important laws, just like NEPA is an important law at the federal level for historic preservation. Now, state planning acts are also very important state laws. They contain enabling laws for local land use decision-making bodies. These statewide acts establish the authorities, terminology, and guardrails for counties and municipalities as they go about enacting their local ordinances. And they also typically include provisions requiring that communities prepare comprehensive or master plans. So these laws set the rules in every state for local zoning and for historic preservation ordinances at the local level. So extremely important. Now, there are many, many other state laws that impact historic preservation. For example, there are pro-density housing laws like California's SB 9 that overrides local zoning to help create more density. There are also state laws that can prohibit things like the regulation of short-term rentals in historic communities. All of these laws can have huge impacts on historic communities, and they all come from the state legislature. There are also many positive state historic preservation laws, like laws that create things like state property tax abatements or grant programs. Moving on to the local level. Local historic preservation ordinances are arguably the most important historic preservation laws in our country. More decisions related to historic preservation get made by local commissions that enforce these ordinances than anywhere else. Local commissions are where probably 99% of Americans will actually encounter historic preservation in their lives. And like state historic preservation laws, there's great variation across the country. I mean, even within one state, there are all different kinds of local ordinances that might exist. And I personally started sorting them into these buckets or these generations. Some of the older, simpler local ordinances I call Generation 1. They often have very broad, non-specific language, things as simple as ensure compatibility with the historic context. Generation 2, which were developed later, often contain detailed written guidelines and descriptions of specific local historic contexts. these can often be difficult for the public to understand when you have really long, dense passages of architectural terminology or planning related terminology. So generation three, the current best practice, it involves even more written guidelines and also, in addition to great detail, tools to help the public understand uh, not just the guidelines of the ordinance, but also the context in which those laws exist. I always like to say that someone from anywhere in the country should be able to read your community's local guidelines and completely and clearly understand what will and won't be permitted by your local historic preservation commission. Just to give you an idea as to how detailed design guidelines can be, this is the table of contents for the design guidelines associated with the historic preservation ordinance for Williams, Arizona, which is a town with a population of only about 3,400 on Route 66 near the Grand Canyon. You can see the level of detail that they've gone to. And it's not just about having detailed written guidelines, it's about the tools as well. So in addition to written guidelines, Williams provides images of exactly what they're talking about in terms of their local context and the architectural terminology and elements that they're referencing. Here's another example of those kinds of tools from Charleston, South Carolina. In some cases, a drawing is better than a photograph, as you can see on the left. And on the right, there's an approval matrix that's also intended to help guide applicants to help them understand what will and won't be approved. So it's not just historic preservation ordinances that matter to historic preservation at the local level. There are typically multiple municipal and county bodies that deal with land use and policy decisions that affect historic preservation. So for example, let's take a quick look again at Charleston, South Carolina. At the top of the municipal government structure is City Council, which ultimately makes most of the big decisions about historic preservation and land use upon recommendation by from the local bodies. Next on the list is the Planning Commission, which is responsible for evaluating applications like the rezoning of properties, say into or out of a historic district, or changes to ordinances like local historic preservation ordinance amendments. Next, the Board of Zoning Appeals. Here's requests for variances and special exceptions, like, for example, a request by a developer to build something higher than the allowable zoning limit or with more density. And do note that unlike most of the other bodies on this list, appeals for Board of Zoning Appeals decisions typically go straight to court rather than to City Council. And that process usually depends on state law and state planning acts. The Board of Architectural Review is what the Historic Preservation Commission in Charleston is called. They've got both a large and a small, depending on the size of the project. And it's the job of the Board of Architectural Review and Historic Preservation Commissions across the country to interpret and apply the local historic preservation ordinance and the associated guidelines. In Charleston, the Design Review Board is also an important design review body. Its purview is just outside the historic district, but decisions made outside the historic district as to the scale, massing, architectural direction of major developments can often have major impacts upon historic resources. Same for the Technical Review Committee, which in Charleston is where things like what trees are retained on a property or how drainage will work is decided. And for major developments like subdivisions, these can also be really important decisions that affect historic preservation. So the authorities of all these bodies and their roles in regards to land use and historic preservation is typically outlined in the State Planning Act, which we discussed earlier. And this illustrates how historic preservation can touch virtually every aspect of the local land use planning and entitlement process. And to be an effective historic preservation advocate in your community, it's important to be aware of all of these layers and all of these different decision-making venues that exist and have impacts on historic resources. Moving on to our final topic, the execution of the laws that we've talked about today sometimes creates constitutional issues. The two most common constitutional amendments from which historic preservation cases arise are the First and Fifth Amendments. Now, I've also included the 14th Amendment on this slide because historic preservation cases are often evaluated under what's called equal protection analysis, which comes from the 14th Amendment. Let's start with the First Amendment and freedom of speech. Freedom of speech cases do arise in relation to historic preservation. The case on the left concerned a mural within Charleston's historic district that was painted and then denied by the Historic Commission after the fact. Did that violate the artist's freedom of speech? The second case on the slide from Boston concerned attempts to regulate newspaper vending machines. Did that violate the newspaper company's freedom of speech? In both cases, and in all historic preservation related freedom of speech cases, the key factor for the determination is that the restrictions must be found to be a quote appropriate time, place, and manner restrictions on freedom of speech. Also coming from the First Amendment is freedom of religion. The case on this slide comes from a relatively common, this case on this slide comes from a relatively common fact pattern. A church with a historic building and a declining congregation that no longer needs that building, or really a building of that scale. In this case, on the slide, the congregation wanted to sell their church to a developer for a very large amount of money. It was in downtown New York City, and the developer planned to demolish the church and build a skyscraper on the site. When that proposal to demolish was denied by the city and it canceled the sale of the church argued that not being able to sell their church interfered with their free exercise of religion. The court didn't agree with the church in that case, and generally historic preservation laws are considered to be, quote, neutral laws of general applicability that only have permissibly incidental burdens on religious practice. That standard, which was established in Employment Division versus Smith, was somewhat altered by a law known as RLUIPA, the Religious Land Use and Institutionalized Persons Act, in the 20th century. But the underlying acceptance of historic preservation laws as only creating an incidental burden rather than an unconstitutional burden on the free exercise of religion still applies. And again, you'd be surprised at how often these freedom of religion cases and issues arise in this country. Now let's move on to what I think is the most important aspect of constitutional law for historic preservation: due process. Due process requirements come from the Fifth Amendment, and they include procedural due process, like the right to be heard, which includes the right to notice and a public hearing. Insufficient notice is a real issue, especially at the local level. This is an issue where it's literally do it right or do it twice. If you don't properly notice a public meeting, you're going to have to void it and hold it again. Or if a staff level approval is granted for something that should have merited a public meeting, you're going to have to do it again. Even more problematic than procedural due process is substantive due process, which includes the right to an impartial proceeding. This includes prohibitions on conflict of interest, bias, and ex parte communications. And with conflicts of interest and bias, again, you'd be surprised how often these issues arise. My general advice is always, if you're asking the question as to whether there's a conflict of interest, or if you're asking the question as to whether there's impermissible bias, those individuals should probably recuse themselves from the decision-making process. That's what my ethics professor in law school always said, is if you're asking the question, you already know the answer. Now, the last thing on this slide, ex parte communications, occurs when members of a decision-making body have improper conversations outside of public meetings about potential projects. For example, when I was working in Charleston, there was a development that was stuck in the entitlement process, and the chair of the Historic Preservation Commission decided to try and sit down with the developer and sit down with some of the development opposition outside of the normal public meetings and sort of strike agreements, negotiate. That is textbook ex parte commissions that then undermines the ability of this commission to have an impartial hearing and actually make a decision at a later date. Lastly, it's important to know that all governments, federal, state, and local, are prohibited from engaging in what's called arbitrary and capricious decision-making. So this claim is the basis for many of the legal challenges in our field, whether it's the National Trust challenging a federal agency's improper execution of the Section 106 process, or a developer challenging the denial of one of their projects by one of the local boards that we reviewed earlier. Fundamentally, the government has to engage in decision-making in a reasonable and well-reasoned way. And this arbitrary and capricious standard is incredibly important because, again, it appears in the vast majority of legal filings challenging decision-making in a historic preservation context. Lastly, I'll briefly touch on governmental takings. First and foremost, big, all bold, take this away from this lecture, please. Zoning is not a taking, and it hasn't been for almost 100 years in this country. So being included in a historic preservation zoning overlay, which is the same thing as being included in any other kind of zoning, is not a taking. One thing that can be a taking is when the government denies a permit, Unfortunately for historic preservation, one of the most seminal cases in all of property law, known as Penn Central, specifically dealt with the historic preservation issue. And in that case, the Supreme Court held that permit denials based on historic preservation concerns do not constitute governmental taking because it's a legitimate government interest. Physical takings, or eminent domain, are the other type of governmental takings. The most famous case in this area is Kelo versus the City of New London, which a movie was made about a few years ago. That case created an unfortunate precedent that the government can take private property simply to turn it over to private developers if those developers' plans will result in greater economic benefits. And the National Trust has recently been involved in litigation challenging just such a situation in New York City, where the state proposed to declare a substantial area around Madison Square Garden as blight to justify an eminent domain taking. The area included multiple historic buildings that would have been demolished, and the state plans to turn the land over to a private developer to build multiple skyscrapers to the great enrichment of that developer. And interestingly, the land that's the subject of this case, Madison Square Garden specifically, is the site of the original Penn Station, where everything started all the way back in 1963, which brings us full circle back to the beginning of the historic preservation movement and its maturation in this country and the enactment of the National Historic Preservation Act. So thank you very much for the opportunity to speak with you today. As I said at the outset, we covered a lot. I hope that you come away with some new knowledge and are at least aware maybe of some laws and legal concepts that you weren't aware of before. And if you have any questions or would like to learn more, my email address is on this slide. Thank you.
Thank you so much, Chris. I know I gave you a monumental task in trying to summarize federal preservation law, but you did an incredibly thorough job in providing an overview of our federal system. So thank you so much once again. I'm looking forward to following up on a few of your points during the Q&A portion of the webinar, but first, I'd like to introduce our second speaker, Shannon O'Loughlin. Shannon is a citizen of the Choctaw Nation of Oklahoma and the chief executive and attorney of the Association on American Indian Affairs. Shannon has been practicing law for more than 24 years and has a long list of accolades and accomplishments, which I'll try to briefly summarize. In addition to her current roles, she is also a lecturer at Johns Hopkins University and serves as vice chair on the board of Native Ways Federation, which educates about informed giving to Native-led nonprofits. She is also former chief of staff to the National Indian Gaming Commission, where she assisted in the development and implementation of national gaming policy and oversaw the agency's affairs, technology, compliance, and finance divisions. Shannon also served Native country in the private sector as an attorney, leading a Native Nations law practice group at a large national firm that worked to strengthen, maintain, and protect sovereignty, self-determination, and culture. Additionally, in 2013, she was appointed by former Secretary of the Department of the Interior, Sally Jewell, to the Native American Graves Protection and Repatriation Act Review Committee. And in 2015, she was appointed by President Barack Obama as the first Native American to sit on the Cultural Property Advisory Committee within the State Department. Shannon received a BA in American Indian Studies from California State University, Long Beach, and joint MA and JD degrees from the University of Arizona in Indigenous Peoples Law and Policy. So Shannon, thank you so much for joining us today. I hope I managed to note all the highlights in your professional career, but if I left something out, please let me know. And other than that, please take it away.
Thank you so much. I'm really happy to be here with all of you. Let me get my slides up real quick. And here we go. Thanks for joining me. What I'm going to be talking about today is protecting Native cultural heritage, and I'm going to introduce the topic and talk about it more substantially through the purview of the Native American Graves Protection and Repatriation Act. So let's get started here. And I wanted to just give you a list of cultural heritage laws that are federal that may apply to archaeology, ethnographic materials, in situ, at a site. It could also include the theft and looting of those items from Native nations, from federal, state, tribal lands, also require repatriation and return of that cultural heritage back to Native nations. So there is a long history of considering Native cultural heritage, but really it wasn't until the 1970s, specifically with the American Indian Religious Freedom Act, where the laws that were being developed in cultural heritage were meant specifically to benefit Native nations and Native nation citizens. Before that, most of the laws were meant to benefit others, benefit archaeologists, benefit science, benefit the federal government, but not necessarily to benefit Native nations. All of these laws are complex federal laws. They provide a checkerboard spread of what's actually protected and what's not. And so, depending on the facts of any particular case, different laws are going to be used to protect cultural heritage. And what's not listed on here, which Chris introduced us to, were also state and local laws that could potentially apply to protect Native cultural heritage. And what was missing from Chris's list is there's also a body of Native nation or tribal laws that each of the 574 federally recognized Native nations within the United States, and even more than 300 other non-recognized tribal communities and groups have their own laws that relates to cultural heritage. And specifically what you will see in many of those laws, whether it's part of their written legal structure or part of their custom and tradition practice, which is also recognized by courts, is a jurisdictional statement quite often in which the Native nation asserts jurisdiction over all of their cultural heritage, regardless of where the cultural heritage is located. And so including and understanding Native nation laws is important in the protection of Native cultural heritage. But regardless of all the laws, I want to remind every one of us that there is probably a set of values that we all adhere to or wish to adhere to, which are pretty basic and which are what I think are fairly represented in this wonderful book called All I Really Need to Know I Learned in Kindergarten. I believe that still applies to us as adults. And I highlighted number 4, 5, and 6 that directly applies to the things that we're talking about today. That it's never okay to take things that are not yours, and if you've messed it up, fix it, and put things back where you found them. If you are a Native person, those principles can also be found in many of our cultural traditions. I borrowed this from the Nottawasepi Huron Band of Potawatomi and their website. These are known as the 7 grandfather teachings, which many Potawatomi, Ojibwe, Anishinaabe people use and practice, which are similar to those things that you knew in kindergarten. And truth and honesty always prevails in this work. So let's talk a little bit about why Native nations. And I want to assert right off the top here that Native nations are not diversity, equity, and inclusion subject matter. Native nations are sovereign, separate governments. Each one of those 574 federally recognized tribes have their own laws, their own authorities over their lands and resources, over their citizens and people. They provide education, health care, and other services to their citizens, just like the federal, state, and local governments provide to their citizens. There's a body of law called federal Indian law, I suppose appropriately, that arises from treaties that were entered into between European nations and Native nations, as well as the United States and Native nations. Um, uh, Native nations are in the U.S. Constitution, and Congress has authority based on that Constitution, a promise of protection, if you will, a trust responsibility, also known as a government to government relationship. And so in the Constitution, that gives Congress the authority to pass laws that are for the benefit of Native nations based on treaties in the constitutional relationship of tribes to the U.S. government. Again, these are not DEI programs, and nor are these laws or the federal framework of federal Indian law based on race. These laws are based on the political government-to-government relationship between the United States and Native nations and their citizens. There's also a plethora of federal court decisions related to federal Indian law and other federal law that relates to this body of federal Indian law. You can look at Title 25 of the U.S. Code. That entire title is devoted to federal Indian law. And how courts look at federal Indian law when they're interpreting ambiguities in statutes and regulations is they use what's called the Indian law canons of construction, so that any ambiguity in a statute, in the four corners of a statute of federal Indian law, is always interpreted as the Native nation would understand it to be. As we'll see soon when we talk about NAGPRA, NAGPRA specifically highlights this special relationship, and that the law was created for the benefit of Native peoples and no one else. And what this does is it creates, when we're looking at protecting Native cultural heritage and that huge body of complex federal law, state law, tribal laws, is there's this federal Indian law umbrella that covers all of it, in which these laws, regulations, policies should be interpreted as Native peoples understand them for their benefit and protecting their cultural heritage based on that government to government relationship between Native nations and the U.S. Again, it's a promise of protection that the United States has given to Native nations through treaties and other federal law that has created that umbrella in how we look and interpret protecting Native cultural heritage. So let's look specifically at NAGPRA and how NAGPRA is used. So the act is in 25 U.S. Code. It was passed on November 16th, 1990. And that law is important in many different parts of the act. So for example, if you are a museum, as a museum is defined under NAGPRA, you would be considered a museum under NAGPRA if you've received federal funds since November 16th, 1990, and have Native collections in your possession or control. So that enactment date is important. And the act simply recognizes the inherent rights of lineal descendants, Native nations, and Native Hawaiian organizations to their ancestors' burial belongings, sacred objects, and objects of cultural patrimony. And those are very clearly defined in the act, and are generally items that belong to a nation as a whole, or belong to a society or a community as a whole. These are not individual items, but are items of their nations and communities. And again, this law was passed by Congress for the benefit of Native nations. And it calls out that special relationship between the federal government and Indian tribes, in which should not be construed to establish a precedent with respect to any other individual organization or foreign government. So the Congress was extremely clear here that the benefit of this law was to be put on Native peoples, not institutions, not federal agencies, not museums, but this law is to be interpreted to benefit Native people. The regulations were recently completely redone. The law has been on the books for 30 some odd years now. And compliance with the act was, especially by institutions and many of our ivory tower institutions as well, they're just refusing to comply with the law. And the regulations were extremely faulty. For example, the regulations did not even define what consultation meant and how an institution was supposed to consult with a Native nation. So these new regulations went into effect in January 2024. And we're going to talk in a little more depth about those regulations. But also, to just close up this slide, I want to make sure you understand that NAGPRA applies to repatriation, which means if there are cultural items that are within an institution or federal agency who's received federal funds, those items are required to be repatriated to affiliated nations. And also within NAGPRA is graves protection provisions. And the graves protection provisions within NAGPRA, again, this is kind of a checkerboarded law, only covers federal and tribal lands. So if there is a cultural site or cultural heritage that's not on federal or tribal lands, it's on state or private, then NAGPRA may not apply. A state law may apply, or other local ordinance. And again, as we heard, every single state has a different framework, and likely is not very protective of Native cultural heritage. Okay, so again, under this federal Indian law umbrella, we're going to go over quickly the key concepts that we find in NAGPRA that apply to the graves protection and repatriation provisions, which are listed here, and I'm just going to quickly go through them, but reminding you that these should all be viewed under that umbrella of for the benefit of Native nations. One of the first concepts we find in NAGPRA and that we should consider when we're looking to protect cultural heritage, regardless of what law we use, is what right of possession means. The federal government has clearly defined this principle as requiring voluntary consent from the authorized person or persons within a Native nation at the time of the original acquisition. So if you're within an institution and you see that you have whether it's a bill of sale or a gift, maybe from a general in the Army, that likely was not a gift from a Native individual or the proper authority within a nation to an Army general. Quite often when we see that in records, that Army general likely took the item through war, violence, or otherwise, because there were many policies that the military and the federal government asserted against Native people as part of the federal government's genocide and assimilation policies of Native people that really didn't end until after the 70s, 1970s. So this concept requires an individual, in order to have a right of possession, to have gotten consent at the time of taking of the item, that wasn't unconscionable or due to violence or otherwise. Another concept that's extremely important within NAGPRA and how NAGPRA is carried out is its duty of care. These regulations, and also it's really important to look at the language. It's almost like poetry. This is kind of nerdy, but some of us attorneys really like legal language because it's specific and clear. Every comma is accounted for. So it's important to remind yourself about words like require and must. Those are mandates that must happen when stated in a law like this. So for the duty of care, these regulations, NAGPRA, require a museum federal agency or Department of Hawaiian Affairs to care for, safeguard, preserve any ancestors or cultural items in their custody or possession or control. A museum or federal agency must consult, incorporate and accommodate Native American traditional knowledge, and, so not an or, and obtain free, prior, and informed consent before they can do anything with a Native American collection. And of course, this applies both to the graves protection provisions and repatriation provisions. Let's dig into those three: consult, traditional knowledge, and free, prior, and informed consent a little bit more. I had said before that consultation wasn't even defined in the initial regulations. Now they are fully defined, and what it's describing here is a collaborative process between Native people and the institution or the federal agency. That requires the agency to enable meaningful consideration of Native traditional knowledge. And throughout the law, you'll see references to Native traditional knowledge and how cultural items are defined. So if you don't understand what a sacred object is, the Native nation that you're consulting with, who is the primary expert of their own cultural heritage, their traditional knowledge should be deferred to according to NAGPRA and the language within its consultation requirements. Native American traditional knowledge is also fully defined by the law, and I'm going to read it real quickly and we won't stay too long here. Native American traditional knowledge means knowledge, philosophies, beliefs, traditions, skills, and practices that are developed, embedded, and often safeguarded by or confidential to individual Native Americans, Indian tribes, or the Native Hawaiian community. Native traditional knowledge contextualizes relationships between and among people, the places they inhabit, and the broader world around them, covering a wide variety of information, including but not limited to cultural, ecological, linguistic, religious, scientific, societal, spiritual, and technical knowledge. Native traditional knowledge may be, but is not required to be developed, sustained, and passed through time, often forming part of a cultural or spiritual identity. Native traditional knowledge is expert opinion, and that comes directly from the statute itself. Now, free, prior, and informed consent has been a bit controversial. You may have seen maybe about a year ago that institutions like the American Museum of Natural History were shuttering exhibits in institutions because they had not consulted and asked for consent from Native nations before they used collections that were in their possession. And free, prior, and informed consent is this provision is also the first time the United States has acknowledged the UN Declaration on the Rights of Indigenous Peoples bringing forward language of free, prior, and informed consent to implement it as the UN Declaration has and the United States has accepted and recognized that declaration. This requires free, prior, and informed consent for an institution to do anything with the Native collections in its possession. And part of this process and this duty of care is so the institution can make a determination of cultural affiliation. And what this determination is again, it's a collaborative effort to make a reasonable connection of a shared group relationship between the item or the ancestor and the present day Native nation. And this is not a research project. This is not a PhD dissertation. This is a simple administrative process in which the institution or agency simply takes the information that is known in their records, consults with tribes, and makes a determination, a reasonable determination, so that it's more likely than not connected. That ancestor and the Native nation is connected, even if there's reasonable gaps in information, even if there's not enough for a scientific determination of cultural affiliation. Again, this is a legal process. This is a reparative action to return stolen and removed items that never were consented to be taken in the first place. I'm going to move through, we're not going to go over timelines. I do want to let you know, if you're involved in the repatriation provisions of NAGPRA and that practice, that there are some federal funds available and some timelines coming up. And I want to share with you that there's a few resources and further training if you want to get in deeper to what NAGPRA is. The National NAGPRA program has quite a bit of templates and videos available. There are also communities of practice out there, both nationally and regionally, that brings together tribes and practitioners that are working in the area to help build networking and better understanding of the issues at play. The Association on American Indian Affairs is a national Native nonprofit that's been around since 1922. We have a Tribal Partners Working Group, and it's similar to a NAGPRA community of practice. It's an internal Native nation representative group who come together once a month to talk about issues of repatriation and also the sensitivity issues around the work that's involved with bringing home ancestors and sensitive cultural heritage. I do want to let you know that the association has a large grant, and we've been developing an asynchronous course that's going to be available online for free, free access, and we're hoping to see that in late spring, early summer come out. So I hope you'll check out our website and maybe sign up for our news alerts so you'll know when that education is available. Thanks so much, and I can't wait for questions.
Thank you so much, Shannon, for sharing your knowledge on heritage legislation for Native communities and for all those recommended resources in that last slide. Everyone, as I said before, we will be linking recommended resources, including all of those that Shannon just had on the screen, on our website in the near future. So check back on the Bridging the Gap webpage for those. Shannon, I know I have a few questions for you, just like I do for Chris, and I see we also have several in the Q&A. So perfect, Chris, you're back. Let's dive into some questions. The Q&A function is still open, so if any of you in the audience would like to contribute more questions, please feel free. But there was one that looked like it would be really good to start with, kind of a more general question. And I think since the question is directed to both of you, we can just answer in the order of speakers. So first Chris and then Shannon. This person asked, in your opinion, what cultural assets are not protected enough? Where do the laws that you both talked about today fall short? And how do you think these protections can be improved in the future?
Well, I guess since I went first, I'll start. All of them, we can protect all of them more and better than we currently do. Uh, in my mind, one of the areas that we struggle is protecting newer and more recent assets. There's a concept called period of significance that's currently written into the National Register. And it requires, say, a National Register district to identify what its period of historical significance is. And in many cases, there are historically important buildings that are from outside of that period of significance. So, if you've got a city where your period of significance is 1840 to 1890, a great building from the 1920s might not be eligible to be included as a contributor in your historic district. So I think that one of the challenges we have is constantly updating our historic properties inventories to reflect changing and ever expanding periods of significance. And because of that challenge and how much work it creates, there are a lot of mid-century resources, a lot of latter half of the 20th century resources that are definitely historic and important to communities, but are more difficult to protect. I, for one, am a fan of the proposal to just eliminate periods of significance altogether. And I think it would really be beneficial to more modern historic resources.
Yeah, and I think I would what's not protected enough. So I would want to throw out there the premise that it's likely there's more Native cultural heritage in the United States, and of course it's been moved all around the world um, uh, because Native peoples have been here longer than the colonial governments have. So our cultural heritage has been looted and obscured for quite a bit longer than non-native cultural heritage in the United States. In addition, the laws protecting native cultural heritage are quite checkerboarded. So where federal and tribal lands may be protected to an extent, state and private lands may not be, and it's dependent on the framework of state and local laws. And quite often, those state and local governments are really bad at working with Native nations, consulting with Native nations in order to protect Native cultural heritage. And so I think that's a terrible policy. For one, I think when the state and local governments destroy Native cultural heritage and don't involve Native nations, they're missing opportunities to grow good relationships within their state, grow tourism, grow understanding from their own people in their state about the importance of all the feet that have walked on those lands. I would pose that Native cultural heritage, sacred places, and sacred landscapes outside of federal and tribal lands are not well protected. In addition, there's a huge concern with the current administration opening up federal and public lands for all types of extractive development, housing, and other issues that would completely destroy some of the last vestiges of protected cultural spaces we have.
One thing that you said really stood out to me was that in summary, a lot of these shortcomings result in missed opportunities. And I think that can also be applied to what Chris was saying with the protection of modern heritage. So I think, yeah, maybe at the government and implementation levels, if we were to view protecting cultural heritage more as, if we don't, it's a missed opportunity. If we could maybe, if everyone could kind of change their perspective and view it from that point, I think that would be a significant change in and of itself that would lead to some amazing consequences. We've got another question here that kind of ties into what we're trying to accomplish with this webinar, taking what we've learned and applying it into practice. So someone asked, in practice, where do we see the applications of heritage legislation? Do we see them more in courtrooms, at local city halls, in private practice, like in offices of the National Trust or in offices of a CRM company? Basically, like, where will professionals encounter these laws and the need to apply them? And feel free to use examples from your own careers if they're applicable. So, Chris?
This is a fantastic question. And, as I said during my presentation, 99.9% of the American public's interaction with historic preservation comes through local bodies, local commissions. Your local ordinances are a form of legislation. And I think as a practitioner, you might encounter those laws either if you're working on a project that needs approvals or if something's just happening in your community that you're interested or involved in. A lot of consultants and practitioners, though, do interact with the Section 106 process and some of these other processes doing projects in a consulting capacity for federal and state agencies. So I think that, those two, as a professional, you will probably see, will probably interact with these laws as part of those compliance processes. But, in general, for most people and maybe for some practitioners, depending on your area of practice, the local entitlement process and those boards will be where you run into these laws.
Yeah, I'd like us to consider what it means when we let go the majority of National Park Service employees and other federal workers whose jobs it was to protect cultural heritage. So my concern is where we're going to see this most is locally with looters who are now emboldened to go in without any watchful observers and continue to loot from cultural heritage sites all over the country. And I would also want to share that Native nations, this is a daily event. So they're constantly getting calls about someone digging somewhere, things being found, and there just doesn't seem to be a lot of will or understanding that Native people still exist, that Native people want to understand their own histories, and as do many other people. And then when looting happens like this, it destroys the archaeological context and the ability to really understand what happened in that place or location. But people still feel like that they can earn money. They can market these types of items because there is still a strong, you can go to eBay, Facebook, and auction sites all over the world and still see our sensitive cultural heritage, even boldly asserting certain federal sites with looted items that organizations like the Association on American Indian Affairs monitors and alerts the FBI and other law enforcement about. So this is, in practice, we unfortunately see this happening through illicit trafficking quite a bit. We don't see enough of it in court because a lot of the laws are a bit weak, or at least the criminal laws are a bit weak. So yeah, I'll stop there. Thank you for that.
I just want to jump in really fast and really support what Shannon just shared, that looting is a very serious problem, and it does happen far more often than I think most people would imagine. And she's so right.
I agree. Kind of related, maybe, to that, Shannon. We do have a really interesting question I'd like to pose to you. Um, this person asks, what can the United States learn from other countries that have tribal groups and are facing similar challenges in protecting their cultural heritage and traditions? For example, Australia, how the Australian government, how do they work with Native communities? What laws do they have in place? Um, I don't know, kind of tying into that, I'm not sure exactly how much, maybe you know, do Native communities in the United States look to other countries like Australia with similar setups to try to see what can we learn from them to improve the protections we have in our country?
So countries like Canada and Australia, who have indigenous populations that they've recognized in a different way than other countries have, um, uh, they're kind of behind the U.S. as far as the establishment of federal law that recognize Native nations as sovereign and separate governments. Australia and Canada are behind us on that. Um, what I've learned from studying international law in various countries, and also in through my participation in the Cultural Property Advisory Committee in the State Department, um, is that there are many countries, especially countries in South America, whose um, uh, framework of protecting cultural heritage is much more comprehensive than the US. I talked about how US laws are really checkerboarded and it's dependent on the status of the land, who owns the land, and who has jurisdiction over it. Whereas in other countries, even Guatemala, have more national legislation that has no checkerboarding. If there is cultural heritage related to that country whatsoever, it cannot leave the country. It has to be protected. It has to be disclosed. Even private holders of cultural heritage from those countries are required to disclose the items so that they can be protected and secured because the country values the cultural heritage in a much different way than how the U.S. values it. The U.S. Often pegs interests in culture and human rights against economic value. So if it's worth more to dig up a ground and create waste in order to bring more coal or lithium out of the ground, then it's likely that interest is going to prevail over protecting culture as sacred and clean spaces. So I think we can look to other countries that have stronger values in human interest, in cultural protection, and spiritual ways of life over economic interests. That might help us a bit.
I like your comment about the how the US values how we weigh culture against economic issues. And I think that's a good segue into this next question. This person asks, many other countries around the world have a Ministry of Culture. Why doesn't the United States? Maybe economic reasons are an answer. And they continue saying, do you think having a department, maybe not a ministry, since our government isn't set up that way, do you think having a department dedicated to the management and preservation of cultural heritage would help or hinder preservation in the United States? And I'll pose this question to the both of you.
Well, I think this is an opening to bring up a great point that is a favorite talking point of the National Trust General Counsel, Tom Mays. Culture isn't anywhere in our laws. Traditional cultural properties was a designation that's been developed to help capture some of these places that are especially important to Native American tribes. But unlike most other countries, we don't actually consider intangible culture and culture in our laws. It's a huge glaring deficiency that we have in this country. Now, whether we need a full-on Department of Culture at the federal level, I mean, that would be ideal. But just simply amending the National Historic Preservation Act or our other laws to actually consider not just the built environment, but culture is a very important deficiency that folks should be aware of, and that I really hope that we can address as a country in the future.
Sorry, I'm going to look at that question again. Ministry of Culture. Again, our regulation of cultural heritage or protection of cultural heritage is just kind of bifurcated all over the place among various agencies. Quite a bit of it is within the Department of Interior. Nothing is really in the Department of State, where you would think that such a person would be established. What's interesting and unique is when I was served on the Cultural Property Advisory Committee there, my sole job was to ask those folks that went on these diplomatic missions to help educate various countries about protecting cultural heritage and how the U.S. would protect their cultural heritage, is that our own State Department wasn't asking those countries about how they're protecting our cultural heritage that's being exported into their countries. And so quite often our own State Department does not serve its purpose of protecting our cultural heritage in the country, is more concerned with protecting other countries' cultural heritage from being imported here as part of that diplomatic relationship. So I certainly don't think the State Department would be a good place to have such a leadership. And it seems like most of our kind of land-based agencies are in the Department of Interior, as well as the Bureau of Indian Affairs, the National Park Service, and the National NAGPRA program and the American Indian Arts and Crafts Act are all within the Department of Interior. So it seems like there could be a great opportunity there to coalesce all these different departments that oversee cultural heritage to have a more uniform regulatory framework.
Yeah, I agree, especially seeing all of your slides where you guys are trying to pinpoint, okay, here's this process, you can find it here, here's this law, you can find it here. Trying to keep that all straight, I imagine, creates a lot of difficulty for someone working in preservation on a daily basis, trying to figure out, okay, who do I need to refer to, who do I need to work with, etc. And I know we're a little over time, but I think there's two questions that go more into practice that I'd like to kind of steer back to. So one was in practice, kind of related to, I guess, the organization of our laws and ordinances. In the case of cultural heritage, also because we talk a lot about the importance of local voices, local communities, do state laws supersede federal laws? Do local decisions supersede state and federal decisions? In terms of the hierarchy and organization, when we're discussing voices, whose takes precedence?
So federal law reigns supreme, but I think it's important to understand that first of all of these laws exist within the framework of our Constitution. So whether it's a local law or a state law, if it's unconstitutional, it's unconstitutional. Ditto for a federal law. But all of them sort of create their own arenas. So if you are dealing with a state undertaking where there are no federal funds, no federal permits, the only law that's implicated is the state law. And that's the arena that you're working within. If you're dealing with a federal law, it's separate. Where laws come into conflict, where a state law might be in conflict with a federal law does supersede, but we really rarely, at least in my practice, I've rarely seen those instances. Usually you're in one lane or another, with all of them, of course, being answerable to the protections in the Constitution.
Yeah, and I would only add, Chris, that under federal Indian law, it kind of provides the foundation. So states can also do their own NAGPRA law or Native Cultural Heritage Protection Law, um, but it cannot fall below what the federal government has established. So it has to provide either equal or greater rights than what the federal law provides in that space.
Interesting. And then Chris, I think this question would be most poignant to be directed to you. In your opinion, is the variation in historic preservation ordinances from state to state and local community to community more helpful than a standardized set of ordinances across the board, or does it cause confusion?
Every historic community is different with different historic resources, different challenges, different characteristics of their built environments. And it's very important that things like local design guidelines are tailored to the specific community in which they're going to be applied. With that being said, there is a program through the National Park Service called the Certified Local Government Program. It's a certification that's required for local communities to be eligible to receive federal grant funds, which are passed through the state historic preservation offices. And in order to be certified as a certified local government, or CLG, your ordinance does have to have some basic requirements, a certain number of members on the commission, certain, let's just call them, foundational lows. But when it comes to especially developing your design guidelines and the details of ordinances, it's not just helpful, it's imperative that they really be tailored to specific communities to be as effective as possible.
That's a good point. So I think we're going a little over time, but just to close everything out, I'd like to ask a more lighthearted question that might also give our audience a better insight into what it means and apply them. And so I have a question here that asks, when it comes to applying the laws discussed today, is there a case you worked on that stands out in your career? Chris, if you'd like to go first, and then we'll close out with Shannon's response.
Oh man. Many, each one of those slides was like, you can unpack it into a half dozen situations. I would say that right now, I've been involved in I'm currently still, in a sense, involved in one of the most remarkable cases I've ever worked with, involving a proposed grain terminal in the state of Louisiana, in the middle of what is currently being evaluated as National Historic Landmark District, Louisiana's Plantation District. The grain terminal will be the size of the Louisiana Superdome. It would go right next to Whitney Plantation, one of the most important plantations for the interpretation of slavery in the country, if not the most important. It's really a terrible, terrible project that has the full support of the state of Louisiana and of Louisiana's congressional delegation. And a 2-year Section 106 consultation became the most controversial and rancorous one I've ever been involved in. We're talking FBI investigations, corruption, all kinds of absolute insanity, massive media coverage, op-eds from the governor, inquiries from Congress. And in the end, the Section 106 process, which was being administered by the Army Corps of Engineers, did its job, and the permit applicant backed away and abandoned the project because they slowly, were made to realize that the adverse effects that it would have upon these nationally significant historic resources were so drastic and severe, and it would forever change this incredibly important place in our country, that they walked away from the project. Now we've heard that under the Trump administration, it might be coming back. They've worked to have some historic designations removed from the area by the Department of Interior to pave the way for that in recent months. But to me, it's an example of how these processes that seem so legalistic and tedious when you see them in a slideshow like what I just presented have real world impacts that change the lives of communities, that really do save places. And I really firmly believe in these laws. I believe in their effectiveness and their importance. And the Greenfield Terminal case is one that has really reaffirmed my confidence and belief in the Section 106 process recently.
Wow, the way you talked about that, I would watch a series if Netflix or someone decided to go over it. From a preservationist perspective, I think a lot of us would, with all the drama that you just alluded to, I think it has some potential. We should reach out to Netflix, maybe.
We keep hearing that. People keep talking about it. When it's finally all over, when hopefully they finally go away. Yes, that is very much in the offing.
Interesting. Well, I look forward to it potentially. Shannon, how about you?
Ooh, yeah, I have the same problem of wondering which story to tell. So I'm going to tell the story of Sotheby's wampum belt. Uh, uh, an item of cultural patrimony that could also be considered a sacred object under NAGPRA is a Haudenosaunee wampum belt. And those of you, Google it if you don't know what a wampum belt is. But generally, they consist of different shells, purple, white, sometimes pigment is put on them, and they have meaning. They're considered like a Declaration of Independence or a Constitution. So they're a record of events. Or a storytelling device. But I've also seen tribal elders cradle them like a child and able to read and talk to them and feed them. So there's care and caretaking. These are living, breathing items of cultural patrimony that belong to those nations that create them, and they often make them as part of their diplomacy with other nations, and have given George Washington a belt, and there's other nation belts out there. But in this example, there was a couple of wampum belts that were for sale at a Sotheby's auction that we were working to get removed. And through just those couple of items, we uncovered this dramatic story of how they left their First Nations peoples across the border, belonging to Mohawk Band, and how that left through an archaeologist, and how the archaeologists used those belts to trade and get more money with the American Indian Museum, which was the George Gustav High Museum in New York City, which is now the National Museum of the American Indian. And so he brought that belt in, he traded it and got more money so he could do more research and collect other items so that he could bring it back to the High Museum and trade it and get more money. And what we found is that this belt had passed through so many hands through the sale and market. And it was a peace and war belt. So it communicated within the Haudenosaunee Confederacy whether things are good or things are bad. Simply, I'm not going to get into it, but that belt had even been fraudulently, the New York State Attorney General was even in the 70s investigating the American Indian Museum because it was using its collections as a trade and marketplace instead of as a charitable organization, because a museum is a nonprofit organization. And so the institution was acting outside of its authorities as a nonprofit by using its structure to just buy and sell native heritage. So we found this belt, and that it had been moved in trade and wound up with the people it wound up, who were trying to sell it through Sotheby's. Unfortunately, neither Sotheby's or the family that had the belt felt compelled to return it until a family member passed away, so that the other family members were able to do what they desired, which was actually to return the belt back to the Haudenosaunee people. So 10 years after we had done that investigation and followed this belt around its many transactions, it was finally returned in a hotel room in New York City without any fanfare, and it's put back into practice and into care with its Native Nations and Mohawk people. And this is not an unusual story, but a complex one that we find quite a bit in the movement and trade of Native cultural heritage.
Well, from both of your examples, it sounds like applying heritage laws can be tedious, complicated, maybe require a lot of patience if it takes 10 years to see the results of all of your investigation and work, as you were just saying, Shannon, but that at the end, seeing the result of the community or the people impacted makes it all worth it. So I think we'll end on that note. So I'd like to thank you both again for joining us today, for being part of the inaugural episode of the Bridging the Gap from Theory to Practice webinar series. We really appreciate it. And I'd also like to thank everyone who attended today for joining us. This, as I said, will be a 6-part webinar series, and it will take place bi-monthly. So you can expect to see some updates about the next episode, which will take place in, let's see, this is March, April, so in May. It'll be on section 106 because we decided that was going to be a topic way too dense to try to put into a 1-hour webinar. But at the same time, I gave Chris and Shannon the nearly impossible task of trying to take all of their knowledge and condense it into an hour webinar. So for that, I apologize, but you both did a wonderful job, I think, in providing an overview, bringing awareness to different topics and points in legislation. And of course, I look forward to sharing your recommended resources with our audience. So that way, all of the things you couldn't address during this hour, people will still be able to access and read more about themselves at a later date. So once again, thank you both for joining us today. We really appreciate it. And please go to our webpage, sign up for our newsletters, stay tuned into socials to receive updates on future episodes of this webinar series. And with that, I'll say goodbye to both Shannon and Chris and everyone in the audience, and we'll stay in touch. So have a great rest of your day. Thank you again.